What do lawyers do when their client is obviously guilty, especially for insane crimes? Yes, they will defend that person who is guilty. Any witness or piece of evidence can be impeached or ruled inadmissible. If the act is certain, then lawyer argues against the intent. Intent can make the difference between first-degree murder, second-degree murder, and manslaughter. If the intent is clear, then the lawyer can try and argue an affirmative defense of sorts. If the person is found guilty, the lawyer will recommend the best possible sentence for the client. At all points in the process, the lawyer will make sure the state is not exceeding its legal limits. If the law appears unjust, not just the prohibition of murder, but any part of the criminal procedure and the rules of evidence, the lawyer will appeal, although, oftentimes trial lawyers pass hand-off appeals to appellate lawyers, but some do both. All that said, however, the lawyer has to do what the client wants them to do. If the client absolutely positively insists that they did not do it, the lawyer has to proceed with the argument that the person did not do it. A lawyer is required to defend their client because, as you said, everyone is entitled to a defense. The second we start second-guessing that the trials are decided before they begin and anyone we think is guilty is already convicted. Everyone that pleads guilty just gets the maximum sentence. It is crucial, even those the public does not like that have done horrible crimes gets adequate justice, and not revenge. The American justice system is at philosophical odds with revenge. Our system is massively broken, but the ideals for a great system are there. We just need reform to give it a tune-up. A defense attorney's job is to make the prosecution prove their case. Whether their client did it or not is irrelevant. Guilt is determined by the court, not the lawyer. The purpose of the lawyer is to ensure the client gets a fair trial. For a defense lawyer, that means ensuring whatever the prosecution tries to prove is tested thoroughly, that their side is argued fully if they are choosing to plead innocent. I asked a friend who is a lawyer this question. He told me that he saw his job was to make sure the outcome was fair, that every mitigating circumstance was taken into account. He counted a case as a win if the criminal got no more punishment than he deserved. A defense attorney for a guilty client may get moral and ethical satisfaction, for lack of a better word, by making sure that the case has met such rigorous standards that the guilty verdict cannot be appealed. That's what I have heard a defense attorney say, and it makes sense to me. Play devil's advocate so that nobody can argue with the final judgment. Make sure they get a fair trial and fair punishment. Vigorously represent and defend. Ensure there is a fair trial and due process is adhered to. New York has a constitutional right called jury nullification, where a jury has a right to acquit even a clearly guilty person if they feel like it. The Luigi Mangione case might bring that into focus. First, Google the percent of convictions by plea deal. It's upwards of 90 for both state and federal charges. This means going to trial is rare already. Second, look at public defenders versus private lawyers. Public defenders are underpaid, they won't do much. Private lawyers will try to find legal loopholes that get their client minimal punishment. It's why the rich get off so often. They can afford the teams to scour laws and judicial precedent. Justice isn't blind, it sees green. Your scenario is so unlikely because there's over a 90% chance it's solved by a plea deal prior to trial, where the perpetrator accepts lesser punishment by admitting guilt. A lot of times, if the client is clearly guilty, they'll go saying they weren't in the right mental state, try and get them to cooperate with police if they are known to be part of a larger crime ring, or try to convince the jury there is reasonable doubt, since to be convicted you're supposed to be guilty beyond reasonable doubt. Also, lawyers will lie at the risk of their jobs. Some are very good at lying. If you want a good movie, I would recommend The Devil's Advocate. It's not a good realistic movie from a law perspective, but does show how good a corrupt lawyer can be at getting his clients off. Better Call Saul Breaking Bad also can show what a corrupt lawyer can do to get their clients off. I'm not in the US, but I assume this would fairly closely correlate with most Western criminal justice systems. As a lawyer, your highest duty is to the court. You cannot mislead the court under any circumstances. So hopefully, your client lies to you in a fashion that enables you to construct an alternate theory of the crime that is plausible enough to inspire reasonable doubt. If there is overwhelming evidence against your client, you may broach the subject of a guilty plea based on their low prospects of success. If they were to plead not guilty, or there may be some available defenses such as not guilty by reason of whatever lawful excuse exists in the applicable statute. Or you discuss negotiating a plea deal with the other side. If none of the above is possible or consented to by the client, you explain that you can no longer represent them and refer them to a colleague in a different firm with minimal file notes. Something like this: https. Believe that their client is innocent, or that there are circumstances that justify their action change the nature of the case. An attorney needs to be the last line of defense, There's no such thing as obvious guilt which is justified. People get wrongfully convicted. People get framed, charged due to prejudice, slandered, mistaken for someone else, etc. I asked a lawyer this once. He was a defense attorney. He said that the clients are still human beings. That's all he said. Defense lawyers rely on gathering information, conducting investigations, and using legal strategies to defend their clients. However, even if they believe their client is guilty, it is not their job to prove or disprove guilt. Their duty is to provide a zealous defense within ethical and legal boundaries. There's an old adage that goes, if the facts are against you, argue the law. If the law is against you, argue the facts. If the law and the facts are against you, pound the table and yell like hell. Sometimes there isn't much that can be done. Yes, you can probably try to plead insanity, but I'm not convinced mental institutions are much better than regular jail. The drugs they'll give to the guy have extremely nasty side effects. They do the bare minimum, and then get interrogated by the news when it turns out that fire science was outdated and their client was innocent. When your client is obviously guilty with plenty of evidence backing it up, you concentrate into this. That your client gets what they deserve according to applicable laws, but not more than that. There are factors making the punishment harsher or more lenient, like the mental state or age of the accused, the circumstances leading to the crimes. There are countries where you cannot make any kind of deals with authorities or victims for certain or any types of crimes, and countries that allow that to lower your sentence. All countries do not have jury system.